thanks everyone for being here. I'll just walk you through an overview of what different areas or buckets of IP are. So we have trademarks, which essentially protect your name or your logo. We have copyrights, which protect creative works of art. We have patents, which protect a physical device or a software or something of that sort. And then we have trade secrets, which essentially protect things that could be kept a secret. So a recipe, for example, those things are good candidates for trade secrets. In the trademark world, there's all sorts of things that you can protect. So you can protect like I said, your name, your logo. Nike is a good example of that, right? So Nike, the word Nike is protectable. If you think of the swoosh, right? Their logo is protectable. And their slogan, just do it, right? That's protectable as well. So those are some of the things, right? If you have an identifiable mark or an identifiable name that is associated with the quality of your product or something like that, those are good things to protect via trademark. Copyrights are related to creative works of art. So if you think of a photograph or a book or a sculpture or something of that nature, is typically protected by a copyright. So if you're doing paintings or drawings. And then we have patents, which essentially protect a wide gamut of things. So you could theoretically protect software with patents, right? Or systems or processes for doing something. You could protect a device. So if you come up with a new fidget spinner, for example, or something like that, those things are protectable by a patent. And then trade secrets, like I said, will fall under kind of a catch-all category, right? So, if you have a recipe or even a list of customers or a CRM or something like that, those types of things can be protected with a trade secret. There is a fine line between when these things are eligible for IP protection or patent protection specifically related to your question. So if it's an idea in your head, right, that typically, you could consider that a trade secret, for example, right? It's an idea of how you want to do something and the way that you want to do it. Now, it could cross over into the realm of patentability as soon as you have something tangible, right? So under the patent law, the legal requirement is that you have a reasonable expectation of success, right? Once you have that reasonable expectation of success, then you can file for a patent protection. So that's a good, time to go talk to a patent attorney and figure out whether, patents are worth it for you at that point. So that's the legal answer. The practical answer that I like to give clients is that, if you are getting close to being able to market your idea, right? Or even further than that, if you have product market fit, or if you have a good idea of whether you're going to have good product market fit, that's a good time to think about patents, because patent processes are usually pretty expensive, right? So you don't want to just spend that money if it's just a theoretical thing. You'd want it to be pretty close to reality or pretty close to market in order to spend that money. So that's usually my good practical benchmark. It could range based on complexity, but to give you a ballpark number, I would expect to, spend about $3,500 to $4,000 to file what's called a provisional application. And that's like a lightweight application. It allows you to say patent pending, but it's only good for 1 year. So you had to convert that application into a non-provisional within a year. And for the non-provisional application, the full-on application, I would budget about $10,000 for that. And that's to get you through filing stage. And then I would budget another $4,000 to $10,000 after filing to prosecute it, and then you get to an allowance. So all in all, it's around $15,000 to $20,000. I'll give you the legal answer first, because that's easier for me, and then I'll give you the practical answer. So the legal answer is that your invention has to be both novel and non-obvious. Novel just means that nobody should have done it before, and non-obvious means that it can be an obvious modification of something that already exists. Now, you may say, how do I know what's novel and what's non-obvious? The legal answer again here is that it's the federal courts and the patent office will apply the standard of a person of ordinary skill in the art. So basically somebody as skilled as the inventor, right? Would they think this is novel or non-obvious over what already exists? And the trick that I like to tell my clients is that you don't just think about it kind of in the abstract, think about it in terms of how you're doing it, right? So the end goal, the end point could be non-obvious, or how you got there could be non-obvious as well, right? So those are the two things to think about. From a practical perspective, I think it's a sliding scale, right? So if you have a lot of experience in your field of endeavor, if you know what's out there, then you can probably rely on the inventor's judgment about what's out there, right? If you're inventing an entirely new field, right, you don't know anything about that space, then I think it's a good idea to do a prior art search. I also think that there's a sliding scale in terms of the complexity of the invention. So the simpler the invention, the better you are off doing a prior art search. If it's a very complex invention, you can probably skip it. It just depends, right? There's a judgment call there.
Samar, I was going to mention that I contacted the U.S. Patent Trademark Office in the Washington, D.C.
They're
area.
very helpful.
And I was able to talk to someone because their closest office is in Dallas. And they said that they train librarians here. So I'm hoping to be in contact with one of them to, as you mentioned, do some of these searches. So maybe watch for an upcoming event on that.
Yeah, and they do partner with the Central Library from time to time, the Patent Office, and they may talk you through all the different search processes. There are tools at the Patent Office, so if you go to uspto.gov, you'll be able to use the databases that they have to search for patents. And even if you Google USPTO patent search, it will take you to the right place. And I would type in keywords related to your invention. I would, think of modifications of your inventions or your invention in a different context. Those types of things will typically help you find an answer. And once you find something that's close to your answer, the Patent Office also has a classification system. So you can click on the classification, right, which is like a subset within a library of documents. If you click on that classification and do your search again, you'll get much better answers. So there is a process to it. And if you go to the Patent Office website, actually, you'll find some of these tutorials there. They're actually very helpful. And the other thing you can do is call the Patent Office, right? They are a public resource, right? So they're there to help you. And if you call saying that, hey, I'm not an attorney, can you help me? They will direct you to the right place. There is actually a help desk that is built specifically for this purpose. Yeah, for big companies, all these questions are worth exploring and spending time answering and trying to figure out answers to. For startups, for early stage companies, I like to think about it from a strategy perspective, right? So for startups, I always think about what is the patent going to help us do down the road, right? Because this is something you spend money on. And if there is no return on investment, then maybe it's a bad investment, right? So I always think about what is the end goal here, right? So one of the things that I always do with clients is figure out if patents are going to help us get a better valuation down the road, right? So if you're going to raise venture capital, if you're going to raise loans, right? If you get better terms on those things, then it's probably, maybe a good idea to think about patents. If you are going to, get acquired by a bigger company, they tend to value patents very highly, right? So the patents, they may not be something that you can enforce in the marketplace, but it is something that big companies are valuing your company on. So I would think about what are some of the end goals of your company? What do you plan on doing? Do you plan on raising money? Do you plan on getting acquired? Or is that something that's on the table? Those types of things can help you work backwards into whether patents make sense or not. But if you make it a purely legal question, you're going to have a hard time coming up with an answer. Yeah, good question. So I am not the expert here. I might bring some of the other attorneys onto here if I can. But the process is, from what I understand, pretty straightforward, right? So if something is a trade secret, you want to treat it as such, right? So you want to label it confidential or trade secret or something like that. And you want to make sure it's not publicly available, right? So I wouldn't post it on your walls or, something like that. Make sure that the access to it is, protected in some way or limited in some way. If somebody does have access to it, like your employees, make sure you have something in your employment agreement that prevents them from sharing that information. So those are some of the basics of what you can do. David, do you have additional answers for us?
No, honestly, I really don't. I mean, that kind of covers it. I mean, if you think about like the formula for Coke, right? That's a trade secret. And what does Coca-Cola do to keep it secret? only a very, very small number of people within the company are allowed to know what the formula is. And every person who sees the formula has to sign a specific written non-disclosure agreement that relates to the keeping of the formula secret.
We have some clients in that space where we're patenting stuff for them, but we're patenting something very different. Usually we're patenting the system and the algorithm for example, storing things in a blockchain or computing the key for the blockchain and access to the blockchain. So there's all sorts of computation that's happening behind the scenes. That's something that is patentable, right? So that's something that we come in and help patent. The NFT itself is not patentable, but you could copyright it, right? It's a creative work of art at the end of the day. It's a digital piece of art, but it's a piece of art. So you could copyright it. But I think the value proposition of the NFT is not in the copyright itself, it's access to it, right? There's only one copy of it, and that's the real value of it. I would say start talking to an attorney, right? It doesn't hurt to just kind of get a sense of where you are in the process. So we do this all the time. So, as David does clinics, we also do these quarterly things where we would come in and have a roundtable discussion. So you can certainly attend one of those, or you can call the office, not just our office, but any patent attorney's office, right? And say, hey, this is where I'm in the process. What do you guys think? And it's not a bad idea to just get a sense of where you are in the process. And it may even make sense to talk to a couple of attorneys, because I'm sure there's a bunch of judgment involved in this process, right? So two different attorneys may come up with two different answers. So I think the best way to do it is to just be in contact with an attorney and see when you're at that place. They'll probably guide you in the right direction. Yeah, and I'll tackle the cybersecurity question. That's a big one. I have clients in that space constantly worried about ransomware, constantly worried about getting their data leaked, and it can get expensive and embarrassing, right? If your client's sensitive information or your customer sensitive information gets stolen, if it's in unprotected servers in the cloud or something like that, and hackers get access to it, that's a real problem. So there are a couple of different legal things you can do, right? You can have privacy policies on your website. Usually my clients will put it in the footer where they'll say they'll have terms of service, they'll have privacy policies. You can also just have a process, right? A data sanitization process where you either don't collect sensitive information, or if you do, make sure you partner up with a vendor or some kind of provider who can take care of that for you. And if you don't, it's also a good idea to get cybersecurity insurance. That's something that's available, and that's something you guys should look into if you're collecting sensitive data. Thank you guys. Thanks for all the questions.